Good evening, gentlemen. I'm sure we all had quite an awesome an awesome day. Now, you're welcome to tonight's online session. I still remain your host, O.O. Stevens. And tonight we are going to be looking at Trial 2 in criminal litigation. And in Trial 2, we are going to be looking at duties of the parties. We are going to be looking at duties of the parties and duties of the judge. Duties of the parties and duties of the judge. We are going to be looking at it causally. Now, what are the duties of the prosecuting counsel? The duty of the prosecution. I believe by now we all know who the prosecution is. So what's the duty of the prosecution? One is that the prosecution has to be candid and fair. He has to be candid and fair. He must not try to secure conviction by all means. Meaning that if the prosecution notices that there is a particular principle of law that is at the favor of the accused, he should not hold it back from the accused, because the prosecution, his number one reason of being in court is to uphold the cause of justice and not to really make sure that a person has to be convicted. So he has to be candid and fair in all angles. Now, number two is that he must make available to the accused person any evidence that is favorable to him. He must make sure that such is made available to the accused, and a prosecution must be present at the trial of the accused at any time it comes up. We have said it before that where the prosecution is not present, that there is a likelihood of a penalty, which means that the matter may be dismissed, except there are some extenuating circumstances and the court was informed. So a prosecution or the prosecuting counsel must be present at the trial at any time that the case comes up. And it is also unprofessional for the prosecuting counsel to look for a convenient court where the accused should be tried. For instance, now, if maybe this is a case of rape, and you know that particular judge, who is a female, maybe her daughter has earlier been raped, and there is a likelihood of sentiment that may be attached. So you really want her to be the one that will try that particular matter, so that this particular guy who is now being charged for rape will not actually run away from being punished. Such is wrong in the eyes of the law. It amounts to what is called forum shopping. So you should not be looking for a convenient court where the accused person shall be tried. Such in itself is unethical, and it is known as forum shopping. All right, let us look at the duties of a defense counsel. The duties of a defense counsel. One, he is not to return a brief simply because the person has been charged of a capital offense. Meaning that if your client is charged with a capital offense, you cannot return the brief and say that you are not taking the brief again. I hope we all know about the cab rank rule in our RPC, meaning that you have a duty to take brief, except in some instances where you cannot take it, meaning there are exceptions. All right, the next is even where the accused confesses being guilty to his counsel, it is unethical for the counsel to disclose same or withdraw from handling the brief. So that your client told you that he is guilty or that he really did this is not a ground for you not to take the brief, except there are some other reasons. But if the reason is because he has disclosed to you the truth of having done that, then it will be unethical for you to withdraw from taking the brief. And also, the defense counsel has a duty to be present in court in the course of the trial. He has a duty to be present in court during the course of the trial, and he also has a duty to maintain confidentiality for anything he has been told. He has a duty to maintain confidentiality of anything he has been told. All right, let us look at the duties of a please. The duties that we have been outlining are not exhaustive. The duties we have been outlining, they are not exhaustive. So I want us to note that. Now let us look at the duties of a presiding judge. The judge must be neutral and impartial, meaning the court, the duties of the court. You can call it the duties of the court or the duties of the judge. So the court must be impartial and neutral. And also, the court must not interject too much or put damaging questions across to the accused, leading to his conviction or suspicion of his guilt. So the court will not be asking questions that are suggestive of guilt on the part of the accused. So the court has to actually make sure that it is standing or sitting on the fence. Also, the court has a duty to grant all parties equal right of audience in court. So you must not be granting the prosecution a right that is more than the right that you are granting to the accused, and vice versa. Also, the judge must be fair and respectful to the bar. The bar is lawyers and the bench is the judge. So the court must be respectful to the lawyers that are before him in court. We have actually discussed about duties. Most of the duties, we have discussed it in our class on ethics. So you can pick the voice notes that I released on that. You have an appreciative understanding of all there is about duties, both duties from counsel to counsel, duties from counsel to party, duty from counsel to court, duty from court to counsel, all those stuff. So you will appreciate them very, very well. Now let us look at sittings of the court. The court sits by 9 a.m. The court sits by 9 a.m. I believe you can remember in your motion where you say something like, take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon. So the implication of that is that the court sits by 9 a.m. 9 a.m. means forenoon. Forenoon means before noon. Before noon is forenoon. So before 12 midday is forenoon. Then after 12 midday is afternoon. That is why when it is 12, you don't tell somebody good afternoon, you tell the person good day, because that is the middle of the day. But once it is past 12, it is now afternoon. You can now greet good afternoon. All right, now the court sits from Mondays to Saturdays as its juridical days. But in practice, some courts don't sit on Saturdays. But Mondays to Saturdays are known as juridical days. But by practice, some courts don't sit on Saturdays. And also some courts do sit on Saturdays for special proceedings. But Sundays and public holidays are known as non-juridical days. Sundays and public holidays are known as non-juridical days, meaning that the court does not sit on non-juridical days. However, the court may sit on non-juridical days where the parties consent to it. The court may sit on non-juridical days where the parties consent to it. You can see the case of Ososami versus COP. I'm not really good at giving you cases. Why I don't want to do that is because I want you to get yourself accustomed very, very well with principles of law. Once you understand the principles of law, then you can get cases and add to the principles. But the most important thing is know the principles very, very well, because your first class and your comfortable 2-1 is still assured even without a case. So now the court can sit on non-juridical days, but the only basis is when the parties consent to it. So law school may present to you a scenario where you will see that the parties consented for the court to sit on 1st of May. 1st of May being a public holiday, because law school may not tell you expressly that it's a public holiday. Law school may just give you a scenario and they will give you the date. The date in itself is one of the public holidays we have in Nigeria. So it is now your job now to find out. Then they will not tell you now that maybe on appeal that the convict is now appealing on the ground that he was convicted on a day that is a non-juridical day. And law school may now ask you to comment on the propriety of the conviction that was gotten on 1st of May. So you need to first of all look at in the scenario whether there was anywhere that the parties consented. If the parties never consented to that, then the conviction would be irregular or improper. But if the parties consented that the trial should be had on that day, and at the end of the day he was convicted, then he cannot wake up and start saying that the conviction was gotten on a day that is not juridical. All right, let us look at the concept of publicity of criminal trials. Publicity of criminal trials. All criminal proceedings are to be held in public. If you go to our voice note on constitutional safeguards, if you go to our topic under the right to fair hearing, we discuss exhaustively about the concept of publicity of criminal trials. Now, all criminal proceedings, meaning that members of the public members of the public shall be granted unfettered access into the venue where a matter is ongoing. They shall be granted unfettered access into the venue where a matter is ongoing. However, there are some exceptions. However, that meaning there are some instances whereby such will not be held in public and it will still not be a denial of fair hearing. One of the exceptions is where the statute expressly requires it. Where the statute expressly requires that it shall not be made public, then in such an instance, such trial shall not be publicly held. For instance, Section 13, Sub 1 of the Recovery of Public Property Special Military Tribunal Decree of 1984 stated that when you are trying public officers with respect to misappropriation of public properties or public funds, such shall not be held in public. Also, the next exception is that the public may be excluded in the interest of public safety, in the interest of public policy, in the interest of public decency or expediency. The court may decide not to hold that particular matter in public. Also, where the evidence of a minor is to be heard in relation to offense against morality, such shall not be held in public, and very many more. Also, even where the minister or the commissioner satisfies the court that it is in the interest of justice and public interest that this matter shall not be held or should not be held in public. If the court considers such reasons sufficient, then the court shall go ahead and hold the trial in private. All right, on that, we're going to be drawing the curtain on the topic, and I believe our great lecturers are going to do more exhaustive and extensive justice to this by tomorrow. Do take good care of yourselves, and good night.